Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. As we had previously reported, on June 18th, 2026, the United States Supreme Court, in an 8-1 decision in the landmark Hunter versus United States case, addressed the issue of coercive plea bargaining between the government and defendants, where all appellate rights have been waived as a condition of the sentence of the plea bargain between the government and the defendant. The Supreme Court in Hunter rendered a ruling that even where a party such as Mr. Hunter, such as Mr. Kohberger, and so many other defendants are requiring to do more and more, which is to waive their appellate rights, that waiver can be set aside in certain conditions, allowing the defendant to still go on and appeal what happened in the lower court to an upper court. What must be shown is a miscarriage of justice occurred that would be such that it would shed disrepute on the judicial process. As you know, if you've been following the Kohberger case, the case was extremely sealed to the public. It still is to a large part even today, a year after Mr. Kohberger was sentenced. According to the Moscow Police Department and the state of Idaho, it was Mr. Kohberger and Mr. Kohberger alone who committed the atrocious crimes that the public has only started to be made aware of when the medical examiner's report was finally released a couple of weeks ago, that has made many people wonder if it was Mr. Kohberger who committed these crimes. How possibly could he have done it in such a short period of time that the state says that these crimes happened in a mere matter of minutes? And how was it possible that, given the nature of those crimes up close and personal, that Mr. Kohberger did not leave a lot more DNA at the crime scene than what has been alleged? Why wasn't there more of his sweat, tears, red DNA, hair left at the crime scene? And why wasn't his car a treasure trove of evidence, as well as in his apartment, in the office that he utilized at the WSU campus, at his parents' home? With respect to the Hunter decision, the Supreme Court has reminded the public that a decision to plead guilty requires a knowing and voluntary decision to give up the broad spectrum of constitutional rights that a defendant has, including but not limited to the right to remain silent, the right to confront witnesses against the defendant, the due process right, whether it is a federal charge, which would be the Fifth Amendment to the United States Constitution, or under the 14th Amendment, due process requirements. If it's a state matter, all of these rights and more are given up when a defendant enters into a plea agreement. And the rhetorical question that is asked under the First Amendment is, was this a voluntary signing away of constitutional privileges? Was it intentional? Was it knowing? In looking at the Statement of Constitutional Rights that Mr. Kohberger filled out by hand on the 29th of June, 2025, available on the Idaho Cases of Interest website. It is for case number 0124316665, State of Idaho versus Brian C. Kohberger. We have published a copy of this 9-page document on our community page, a link to which is included in this podcast episode, so you can read it for yourself. But if you look at this document, there is information that's crossed out, beginning on page number 2, question number 8. In the last 48 hours, Have you taken any meds, including over the counter? Or have you consumed any beverages which you believe affect your ability to understand these questions or to make a reasoned and informed decision in this case? In other words, this appears to be asking, was this a knowing and voluntary waiver of constitutional rights? It appears he checked yes at first to that question, number 8, and then it's scribbled out and no is checked with his initials. Above that, number 7, it states some medications that he was taking, that he says that he is currently prescribed. It says there, have you taken these meds within the last 24 hours? And he checks yes. And then question number 5, he says he's not currently under the care of a mental health professional, but he has been, in question number 6, diagnosed with a mental health disorder. The last page is signed by him, and under the section, I have reviewed this form with the defendant, there's the names of his attorneys, but there is no information that any of his attorneys have a medical background. Should Mr. Kohberger have consulted with a medical professional before he filled out or while he was filling out this form to ensure it was knowing and voluntary?